The Youth Law Centre is a free and confidential legal service for any young person in the ACT aged 12 to 25 years. The Youth Law Centre can provide young people with legal advice, assistance and representation. Often, legal advice can help you to better understand your situation and figure out which steps you should take to resolve your legal problem. The Youth Law Centre can also give you legal information. If you have any questions about the law and how that affects you, don't hesitate to contact the Youth Law Centre. In this video, we are going to break down what the laws are for possessing cannabis in the ACT if you are aged under 18 years. In the ACT, cannabis offences are dealt with under different laws to other drugs. In 2020, cannabis was decriminalised in the ACT. It is important to understand that this does not mean that cannabis is legal. There are still laws that apply to cannabis which must be followed, and failure to adhere to these rules will constitute a criminal offence. In the ACT, it remains a criminal offence to possess any amount of cannabis if you are under 18 years of age. If police find that you are under 18 years of age and you are in possession of cannabis, even just a small amount for personal use only, the police may charge you with a criminal offence. If you are under 18 years of age and you are found with less than 50 grams of dried cannabis or less than 150 grams of fresh cannabis, the police can choose to either issue you with a simple cannabis offence notice or charge you with a criminal offence. You may also be required to attend a drug and alcohol diversion program. If police issue you with a simple cannabis offence notice, you will be required to pay a fine of $100 within 60 days of receiving the fine. If you pay the fine before the due date, there will be no further action and you will not be required to attend court. This means that you will not be convicted of any offence and it will not show up on any criminal history checks. If you fail to pay the fine before the due date, you may be required to go to court. If this happens, you may be convicted of a criminal offence which will show up on any criminal history check. You will also be required to pay the fine. It is important to remember that whether or not police issue you with a simple cannabis offence notice or formally charge you with a criminal offence is at the discretion of the police. If the police choose to charge you with possession instead of issuing you with a simple cannabis offence notice, you will be required to attend court and you may receive a criminal conviction which will show up on any criminal history check. If you are under 18 years of age and you are charged by police for cannabis possession for an amount less than 50 grams of dried cannabis or less than 150 grams of fresh cannabis, the court can impose a maximum penalty of a $150 fine. If you are under 18 and in possession of more than 50 grams of dried cannabis or more than 150 grams of fresh cannabis, there is no option for police to issue you with a simple cannabis offence notice. Instead, you will be charged with a more serious criminal offence. Maximum penalties for possessing more than 50 grams of dried cannabis or more than 150 grams of fresh cannabis for personal use includes $8,000 in fines, 2 years imprisonment, or both. If you are a young person aged 12 to 25 years of age with a legal issue or question, please do not hesitate to contact the Youth Law Centre at Legal Aid ACT for free and confidential legal advice from one of our experienced lawyers. To make an appointment, just call 02 6173 5410 or email contact@youthlawact.org.au. You can also message us on Facebook Messenger. Just find our Facebook page at www.facebook.com/legalaid ACT. Our Youth Law Centre operates from 9 AM to 4 PM, Mondays to Fridays.